Hi, in this presentation we will discuss about willful infringement of patent and triple damages because of willful infringement. In USA, it is essential to obtain a written opinion from an in-house or preferably an external attorney, patent attorney. That third party patent is likely to be invalid or not infringed before going ahead with a potentially infringing project. And if this is not done, and if infringement suit is successful, then triple damages for willful infringement may be awarded. When potential infringer had actual notice of another's patent right infringement, then he has an affirmative duty of due care, which will normally entail in obtaining competent legal advice of counsel before infringing or continuing to infringe. And failure of patentee to investigate for infringement after getting a warning letter from patentee is an important factor considered by court in willful infringement determination. It may be a willful infringement where one obtains incompetent and only conclusory opinion of counsel only to use it as a shield against later charge of willful infringement rather than in good faith attempt to avoid infringing another patent. One of the factors to be considered for determining willful infringement is whether infringer relied on legal advice. And when this defense relying on legal advice is raised, court may consider the nature of advice obtained, thoroughness and competence of legal opinion presented, and its objectivity. Court will determine whether advice of non-infringement or invalidity or unenforceability could have reasonably been relied on, and whether on totality of circumstances exculpatory factor avoid a finding of willful infringement. And totality of circumstances may include closeness and complexity of legal and factual questions presented, and commercial factors which may have affected infringer's action. There is no rule excluding reliance upon in-house counsel opinion, but in-house counsel opinion may be insufficient, especially if he or she is not a patent attorney and does not examine the prosecution history, file of patent or file wrapper of patent. Possession of favorable opinion of counsel is not essential to avoid willfulness determination. To serve as exculpatory legal advice, opinion of counsel is viewed objectively to determine whether it was obtained timely, whether counsel analyzed relevant facts and explained the conclusion in light of applicable law, whether opinion warranted a reasonable degree of certainty that infringer had legal right to conduct its activity. The opinion need not unequivocally state that client will not be held liable for infringement. Oral opinions are not favored because they have to be proved years after event based only on testimony that may be affected by faded memory and forces of contemporaneous litigations. Party cannot be held liable for infringement for non-existing patent. Party without knowledge of patent cannot be held found liable for willful infringement. Rejection of a license, often without even consulting an in-house counsel, is a factor that tends toward finding of willfulness. Enormous increase in infringing activity during period of stay of injunction pending appeal can appropriately be considered as a part of willful activity that justifies for increased damages. Filing of suit does not stop clock insofar as culpability may arise from continuing disregards of legal rights of patentee. For determining whether infringer acted in bad faith, court will consider whether there was deliberate copying, whether there was good faith belief that patent was invalid or not infringed, infringer's behavior in litigation, infringer's business size, infringer's financial condition, closeness of case, duration of infringer's misconduct, remedial action by infringer, infringer's motivation to harm, whether infringer attempting to conceal its misconduct. Infringement by willness or willfulness is not all or nothing trait, but it is one of degree. Infringement may range from unknown or accidental infringement to deliberate or reckless infringement disregarding the patentee's legal right. Willful infringement is a question of facts and must be established by clear and convincing evidence, specifically when boundaries between unintentional and culpable act are not always bright. Issue of willful infringement is also accompanied by intent, belief, and credibility. Whether infringement is willful is by definition a question of infringer's intent. Whether infringer intended to infringe willfully. Infringer's intent and reasonable belief are primary focus of willful infringement activity inquiry. Willfulness is a determination as to state of mind which must be determined examining totality of circumstances by clear and convincing evidence. Willfulness is generally based on conduct that occurred after patent is issued, and patent pre-issue conduct may also be used to support finding of willfulness. Fact to be proved is that infringement was willful and not that litigation activities were improper. increased damages for willful infringement are punitive and must consider and include some degree of culpability. Only culpable infringer can be held liable for increased damages and not the innocent one. The infringer may avoid enhanced damages by meritorious good faith defense and substantial challenge to infringement. Party that continues its accused infringing activity after patentee filed suit for infringement may not be guilty of willful infringement provided party presents a non-frivolous defense to infringement. Defense to infringement may be in the form of either the patent is invalid or not infringed or patent is unenforceable. Copist relying Copist reliance of Council's Rule 11 obligation to support its assertion that it had good faith belief in invalidity and unenforceability of patent was sufficient to overcome a finding of willful infringement. District Court possesses inherent power to assess attorney fee as a sanction when a party acts in good faith vexatiously, wantonly, or for oppressive reasons. So that's all in this presentation. Thank you very much.